For those of you that I have not met this morning, my name is Keith Robinson. I'm an assistant professor here at the law school. I'm also the co-director of the Tye Center for Law, Science, and Innovation, along with David Taylor, who you met earlier this morning. And I will be doing the hosting duties for the duration of the day. Judge Ward earlier called for a little prognostication, and so we might have a little bit of that. I've assembled a great panel of scholars to talk about various issues with respect to intellectual property. And remember that the theme of this conference is the future of innovation and intellectual property. And so we've had a very patent-heavy morning, and we're going to change it up just a little bit. But first, I want to introduce the panelists. All right, to my immediate right is Professor Tim Holbrook, who's a professor of law and associate dean of faculty at Emory Law School. His recent work has explored the impact of 3D printing on patent law, the extraterritorial reach of U.S. patent law, and the function of patent disclosures. And then next to Professor Holbrook, we have Professor Melissa Wasserman, who is an associate professor, Richard and Ann Stockton faculty scholar, and Richard W. and Marie L. Corman scholar at the University of Illinois College of Law. But Professor Wasserman will be joining the faculty at the University of Texas next year. So she will be a lot closer to us in the university. Professor Wasserman's research is fascinating, and it focuses on the institutional design of innovation policy with a particular emphasis on patent law and administrative law. And then finally, on the far right, we have Professor Peter Yu, who is a professor of law and co-director of the Center for Law and Intellectual Property at Texas A&M School of Law. So Peter was previously held the Kern Family Chair in Intellectual Property Law and was the founding director of Intellectual Property Law Center at Drake University Law School. So Peter is, we're excited to have Peter in Texas, and his research focuses on intellectual property, international trade, communications policy, international comparative law, and the transition of legal systems in China and Hong Kong. And so what we want to do as a panel today is give you 3 vignettes about the future of innovation in intellectual property law. And as I said, we want to change it up a little bit. So we're going to start first with Professor Yu. And Professor Yu is going to highlight the territorial challenges posed by cloud computing and copyright law. So please join me in welcoming Professor Yu.
So I just want to start by thanking the organizers, especially David and Keith. It's wonderful to be here. I'm also very excited that we have the Tye Center right here, and I was actually telling my students at Texas A&M they should start looking at all the events here because Dallas is not that far away from Fort Worth, and they can always come over here. This morning's panel, or this morning presentations are some of the most insightful presentations I've heard. But now you get me, so things are going to go downhill. What I thought I'm going to do is to cover something that's somewhat different from the previous presentations because they are somewhat heavy on patent. So I asked Keith if I can do some diversion. And he actually suggested I talk something about international issues. So what I'm going to do is to actually take you to Croatia. Okay? So this is Dubrovnik, but for those of you who have not been to Dubrovnik, this is basically King's Landing. And it's a very big issue within King's Landing. It's about all the piracy that's been going on. It's not just about the US, but it's also in Australia, in Asia, in a lot of different places. And Game of Thrones, I think for the last few years, is basically the most pirated TV show in the world. And so it's not just only about other countries. So we also have some similar issues. People want to watch Downton Abbey, but they don't want to wait. So some people will order the DVD from Amazon. Some people will go on to other channels to try to do that. And this is another example, Wolf Hall. And when I first presented this one, I actually have to explain to people that this is actually not Sergeant Brody from Homeland. It's the same guy, but it's a different drama. And so that's a very good example. You want to see what's going on in other places. The TV show has already been shown, but it's not yet in your own country. I did not see this as such a big issue until 2 summers ago, when I was in a conference with all the IP professors, and that's around the time of World Cup. And all the IP professors are taking out their smartphone, and one professor actually told me that this is probably illegal, but it's World Cup. And so I think it's very serious, because when you have a lot of IP professors who are very respectful of IP rights, and yet they still feel that it's so important because they are in the UK at that time, and then their TV provider is actually in other parts of Europe, but they want to watch the World Cup, and that's on their phone. Right, so you can see that this is actually a major global issue that's been going on in a lot of different countries. And with cloud computing, it becomes even more complicated because you can easily have the work going into all the different places in different servers, and they have been broken up. And that makes it much more difficult because of the territorial nature of intellectual property rights. The traditional approach to handle a lot of the creative media is basically focused on geography. And so you have copyright in different places, copyright in the US, copyright in Canada, copyright in Australia, but we do not have any global copyright that will handle all the situations there. And so some of the examples I love to use with respect to geographical restriction will be DVD code. And that's very easy for us, or at least for me, to tell my students. If you go onto a DVD, go to the back of it, you can see the code right there. So region 2 is basically for Europe. And there are basically 8 different codes. You go from 1, 2, 3, 4, 5, and 6 in different regions. And then you have 7, and that's basically for airplanes, cruise ships. So if you're on the plane watching movies, that's basically region 7. When I know this, I know I've traveled too much. But at the same time, they do have a special code. And then 0 is basically for the code for like classical music, opera, which can play in all different countries. And for Blu-ray DVD, you basically only have 3 sections, so not 8 different codes, but A, B, and C right there. And so there are some strengths and justifications of having all these geographical restrictions. The first one is sequential release, and it's actually very useful in the old days with Hollywood, releasing the movie first in Hollywood and then go into other places, and that works out very well with respect to the actors, with respect to the producers. They cannot do a press conferences at the same time, so they have to travel, and so you have to decide where they're going to do that. In the last few years, a lot of the blockbusters are actually doing same-day release, or they might actually do it in other countries first. So for example, Tintin was released, I think, in Belgium first because it's very big right there, and also originated there before it comes to the US. Sometimes it's quite useful because of the different season within the Northern and Southern Hemisphere. So if you have a movie about summer during the Memorial Day weekend, you don't want to show it at the same time in Australia, which is in the middle of winter. Right? So you want to wait a little bit during the summer season before you show it, and geographical restriction will actually help you achieve that goal. Another example is price discrimination. It's very effective. So US and Canada is region 1, Mexico is region 4. And so if you actually go down to Mexico to buy some of the DVDs and bring back up here, you might not be able to play it here. And the benefit of that arrangement is that Mexican customers might not necessarily be able to afford US prices. So if you sell the DVDs at a much lower price, then they can actually, you can bring back some of the DVDs, but you cannot play on the machines here. The third one is about distribution and licensing arrangements. And so Harry Potter is a very good example. You have the UK version, and you also have the US version. And the publishers, Bloomberg and Scholastics, they are different. Another example is one of my books. And that's published in the UK by Elgar. But in Asia, it was being marketed by Taylor & Francis. And for those of you who are into publishing, Taylor & Francis is actually the publisher of Routledge, who is a direct competitor of Elgar. Except that some publishers do not always have the distribution arm in different places. So they might ask the bigger publishers to actually help them do that. Sometimes it might be useful because you have to translate into a local language. So Kung Fu Panda here is a very good example where they actually work with the local distributor to translate into the local language, do all the subbing and dubbing, and so that will be very useful. And you don't want to just do this on your own. You want to work with other players. And the final one is about censorship and regulatory standards. And so in China, a lot of the movies are being cut for content regulation reasons. And so some of the movies that have been specially tailored to pass through the content regulation in China may not necessarily be what you want to see. And so if you actually have a separate region just for China, that is quite helpful. And so if you look at China, the whole country is region 6. And so that is not covering other countries. And with respect to piracy, region 3 is Southeast Asia. There's a lot of piracy. And so if you have region 6 and 3 just for China and Southeast Asia, even if the DVDs come to the US, they might not be playable on the region 1 machines. So that can also be quite useful. What are the major drawbacks? So there are a number of drawbacks, but I'll highlight 2. The first one is that it's inconvenient to consumers. So I spent a lot of time in Hong Kong during the summer, and whenever I'm in Hong Kong, I always have to remember whether I'm watching a DVD immediately or whether I'm taking back to the US. Because in Hong Kong, it's region 3. So if I buy a DVD there, if I watch it, I can watch it there. But if I take it back here, unless I got a region 3 DVD player, I can actually not play it. And so that makes it very difficult for a lot of consumers because they have to think about a lot of those issues when they were making the purchasing decisions. Another example is about learning a language, right? Some people may not speak English that well, and they may not be a native speaker. And so usually a lot of the movies from Hollywood will have the subtitles in English and French. Some will also have Spanish. But if you want it to be in, let's say, Chinese or Japanese, you're out of luck. If you want to learn German, you're also out of luck. So when I taught at Cardozo, I have a lot of colleagues who actually want their children to learn Hebrew. So they have to go all the way to Israel to bring back a lot of the DVDs because there's no way you can find Hebrew subtitles in any of the DVDs being sold here. Another example is that it can backfire on copyright holders. So BBC is a very good example. So if you're into like Doctor Who, you are into a lot of those shows, you might not be able to access outside the country even if you are a UK citizen. And so when you try the BBC player, they will say that, well, you're actually not within the region, you'll not be playable. Now this is actually very troubling because a lot of people are willing to pay BBC in order to watch it. And so what they end up with is they use third-party provider, like My Expat Tele. But the problem though is that these third-party providers are not going to turn over whatever they receive to the original creative artist or the producer. Right? So you have people who are actually volunteering to pay and willing to do it, except that they cannot find a way to do that. And so now with the digital environment, especially the internet coming in, that makes it much more challenging because a lot of the access barriers have been broken down. So if you go back to the mid-90s, John Gilmore has a very famous quote, "The net interprets censorship as damage and roots around it." So some of the access barriers that we traditionally seen in the 80s, in the 90s, one of them obviously is geography. As I mentioned early on, if you go onto the internet, sometimes you may be able to access content that is actually from other countries. YouTube is a very good example. Another one is about timing, right? A lot of people may not necessarily want to wait for so long, and so even if you tell people from Australia that it's coming in 6 months, they might still not be happy about that. Third one is about language, and you can actually get the language with all the subtitles, with all the information right there. And then the final one is about technology. If you're unsure how you can deal with it, hacking in the technology is actually not that easy. But for those people who actually do not know how to do it, all they need is to use the Google search and to find out what are the code, and they can do that. That is actually pretty easy. And so what are the solutions? A lot of the time and discussion has been spent on talking about strengthening copyright enforcement, and I think that's important because that's one way to actually get other countries to see how important is the higher copyright or IP standards that will also allow you to actually help the copyright holders. The Internet Policy Task Force actually has a white paper that has devoted, I think, a substantial portion of the white paper focusing on different enforcement measures within a digital environment. So if you're interested, you can actually get it from there. The difficulty, though, is that a lot of users are not that happy. So you might have some of the backlashes from SOPA and PIPER and a lot of the legislation that's gone before Congress. Increasingly, people also talk about the importance of having global distribution platform. And so this is Francis Goury, who is the Director General from WIPO. And so when he was doing an interview, what he said is that if one of the HBO series comes out in a new season in the US, but it's not available in certain other countries, what do people do? Do they wait patiently for 3 months? No, because they are addicted, right? So this is actually from the Director General of the World Intellectual Property Organization, saying that people cannot wait because they are addicted. So what he proposed is actually very interesting, and that's how I actually got the title of my talk. He is asking for a seamless global legal digital marketplace. Now, it's very important, it's a legal digital marketplace. It's not just a digital marketplace. So it's unclear as to how that's going to set up. Some of the discussions that have been going on is there are 4 different paths that will help you set up this seamless legal digital marketplace. The first one, obviously, is through treaty. And that is actually the most effective, but that's also the most difficult to achieve. Right? Think about all the treaties that countries are trying to put together, but it's not going to be easy. And so the idea is that, well, we have copyright in all different countries, and they are territorial by nature. What if we actually have something that's global by nature? Is it going to be helpful that way? And so a good example would be, can we have a new global online access right so that we can actually deal with the situations in different countries? So WIPO has not had a lot of treaties since the mid-90s with the WIPO Internet Treaties, the Copyright Treaty, and also phonograms treaties. But in recent years, we have the Marrakesh Treaty, and we also have the Beijing Treaty. So there seems to be some momentum going on at in that area. But still, it's somewhat challenging to actually negotiate a treaty. And so I think a closer analogy will be what the European Union has been doing. So the EU, when they were facing the issue, they look at 2 different issues. The first one is that it's very difficult to set up a pan-European service for an online music store because you have to negotiate the rights with 27 countries and now 28. And the other one is that a lot of consumers can buy CDs in every store, but they cannot get it from different online platforms. And so what has been proposed is basically unitary copyright titles, although it's still unclear how that will go. And a good analogy in the trademark and the patent area is that, well, we have the community trademark and we also have the Unified Patent Court. But those of you who are into global patent issues, you know that there's a lot of discussion and a lot of the challenges with respect to a Unified Patent Court. And copyright is not even at that stage. The second one is about new choice of law principles. Those of us who are professors, we are happy because it's actually very interesting and intriguing on trying to come up with a lot of those principles. American Law Institute, the Max Planck Institute, International Law Association have different projects trying to do that. The whole idea is that we are trying to get national courts to actually come up with principles that will address the tough issues. The difficulty, though, is that a lot of the piracy is actually happening in courts that do not have strong enforcement, and that also courts, you do not trust them with all these principles. And so that makes it much more challenging. Think about like Ukraine, China, Russia, a lot of those countries that actually have a lot of piracy issues. The third option, obviously, is business model. So basically, at the moment, we have different subsidiaries handling different markets. What if you actually work with them together? And I think some of the challenges with respect to the special arrangement because of the local market, because of the technical needs like dubbing and other things, may be a little bit more complicated. So some of the issues we need to look at is about, for example, royalties and payments. Another one is about whether we need to focus on copyright management information so that we can actually allocate the royalties automatically. And the third one is obviously about the collective societies. Right, so a lot of if you want to make it efficient and easy to do it, you might also need to bring in collective society, but only up to a point. What if some are much more powerful than the others, right? So how are you going to handle that? And the last one is about technology. And so, for example, can we have a global username that will allow us to use the same username when we are working abroad or studying abroad? One of my colleagues from UNLV, Makeda Trimble, also proposed the digital passport, But whenever I use this example, those people who hate passport and ID cards will come up to me and say, no, we don't want that. So I'm now just trying to get people to focus on, well, it's basically like a proxy server. Even though you're not in that location, you're trying to trick the computer to understand that you are in a different location. And so that's what we're trying to do with respect to the global username. So there are a lot of different paths that you can actually achieve that, but at the moment it's unclear as to how we're going to achieve that. So I'll stop here. Thank you very much.
Thank you, Peter. Next, we'll have Professor Holbrook, and Professor Holbrook is going to talk about how the courts, in his opinion, have treated method claims less favorably than other sorts of method claims. So we're back to patents now, all right? Professor Holbrook.
I don't know if that's good or bad all the time, but thank you. Let me get this queued up. Let's see. All right, thanks. So I want to, first of all, thank the organizers at SMU for holding this event, and particularly to Dean Collins and to Professors David Taylor and Keith Robinson. This is a great opportunity. My first time at SMU, so I'm very happy to be here. Congratulations on the establishment of the center. I think that's just fantastic. I also have a strange affinity to SMU, even though this is my first time physically present here, in that my last piece in my tenure package when I was an untenured professor at Chicago-Kent was published in the SMU Law Review, and so I sort of owe, in some sense, my tenure to SMU, so thank you. Now, I appreciate that the patent experts in the room realize that there is a slight misnomer in this title, right? Issue method, patent, claim exceptionalism. When I send this, if I send this out to law reviews, of course, students don't get that difference, so I wanted a slightly sexier title, although I'm sure, of course, the SMU students and my Emory students would know the difference. Now, this is more of a thought in progress than actual work in progress at this point, so some things may seem a little unclear, or I'm not certain where I'm going, and so I look forward to getting some questions. But I got interested in this idea of how the courts treat method and process claims differently, because in my background I did a lot of pharmaceutical litigation, and in that context, method and process claims are second best. What you really want is protection for the compound, right? That's where you get the most robust protection. But in other contexts, people are waving their arms and saying how awful process and method claims are. They're too broad, right? That's where the patent assertion entities operate, is in the business method space. And so in these technologically specific areas, it's different. The concerns with method claims seem different. And then when you start unpacking what Congress has done and what the courts have done, you begin to see a lot of inconsistencies. And so that's sort of the descriptive aspect of what I'm talking about. The prescriptive side, what should we do about it, if anything, is where I'm still sort of wrestling. And so there are clearly examples in the Patent Act where Congress has made it clear we're going to treat method and process claims differently. Section 271G allows for acts of infringement for the sale or use of or importation of the product of a patented process, even if it's overseas. That's the most robust application of it. And it's specific to process claims. Now, of course, it's specific to processes and methods that make something, right? If your process doesn't generate a product, it's inapplicable. But it is a unique provision that deals with method claims. Relatedly, there's an evidentiary presumption. Doesn't get used a lot, but under Section 295, the patentee proves that there's a substantial likelihood that the product was made by the patented process, and they made a reasonable effort to determine the process was actually used, but was unable to determine, then the presumption flips, right? And in that case, the defendant actually has to prove that they don't infringe, but it is again specific to method claims. There are additional limitations on remedies under 271G. We've got limits on remedies for medical processes, although the policies for that is a little bit more about access. And of course, we've got the entire covered business method procedures, which are specific to method claims, right? And even before the EIA, I don't have it included since this has been expanded, but we had the first inventor defense, which was specific to business methods. So there have been times when Congress has deemed it appropriate to treat patented methods differently. And I have no gripe with that, right? That is what Congress does. They make these legislative decisions, and they're allowed to adopt statutes that treat different forms of invention differently. Not a problem. What I am mostly concerned about, though, like what I'm curious about, is when the courts, in the face of a neutral statute, start to carve unique attributes into the law based on the nature of the claim. And here you begin to see a lot of distinctions between system claims and process claims that aren't really anchored in the statutory text at all. And in fact, you begin to see the courts treating these process claims differently and inconsistently. And so that's sort of what got my attention. The big one that I see of this is the way the courts treat the sale or offers to sell of patented methods. Now, a lot of people react, well, how can you do that? A method is intangible, there's nothing that you can sell, and the Federal Circuit generally seems to agree with that intuition. In the BlackBerry case, NTP versus Research in Motion, the court reasoned, although they didn't cross the line, but they said it seems highly unlikely that there could ever be infringement of a method claim by selling or offering to sell the method. That seems more akin to license, but they don't make that a bright line rule, right? There's all this discussion about the legislative history, and they just sort of rain on that parade whether it could ever happen, but then they say, well, we're not going to completely hold that. We just make it really, really difficult, and basically we think impossible, but we're not going to reach that absolute holding. Now, of course, that is actually compliant with our international obligations. If you look at the TRIPS agreement, there is the specific provision that says you can infringe a method claim by using it, right? That's the only way you can infringe it. So in that sense, there's some consistency with what the Federal Circuit did in NTP and with our international obligations, and perhaps with our intuitions about the way method and process claims operate. The problem comes in when you start looking at the idea of commercializing method claims in other contexts. So the first sale doctrine, exhaustion, the Supreme Court made it clear in Quanta that in fact you can have a first sale of a method claim. That exhaustion doctrine applies to method claims. But that means in some sense there's got to be a triggering sale that exhausts the patented method, right? What is that link? I thought you couldn't sell a method, but apparently the Supreme Court thinks that you can, right? So there's some disconnect there, but even more of a disconnect, I think, is that the Federal Circuit has made it clear that the on-sale bar does apply to method and process claims. So in some sense, you can offer to sell the invention before the critical date, whichever date you want to use under 52 or the AIA, and you lose the right to obtain a patent on that method. So what's the difference, right? Why do we say that you can't infringe by selling or offering to sell, but you can lose it on the on-sale bar, when in my eyes, basically in both contexts, you're concerned with economic appropriation of the invention in some sense. On-sale bar, you lose the right to get to the patent, you acted prematurely. On selling or offering to sell after the patent issues, we're dealing with infringement with appropriation of the economic value by a third party. Yet the courts treat these distinctly, and they seem to think, well, golly, there's nothing to see here, move along, right? They don't really engage it. Now, what's interesting, and one of the things I'm trying to think about is, does this matter, right? Or do we end run this distinction with damages? And so what happened this summer was the Carnegie Mellon case dealing with a method claim about how you do some reading on hard drives. And in that case, damages, the reasonable royalty, was actually tied to the sale of the disk drives, right? And so there's some interesting language in that opinion where they say it's dealing with territoriality, which I'll get to in a second, but it's an interesting spin where they somehow manage to conflate everything, where a physical product is being employed to measure damages for the infringing use of patented methods. We conclude territoriality is satisfied when and only when any one of those domestic actions for that unit, e.g. sales, is proved even if others, e.g. making, using, take place abroad. So in doing the damages measurement, they're using damages based off of sales and making to provide a remedy for the use of the method. So it may be in some sense the Federal Circuit in that case did reference Quanta, so they're aware that there's this weird tension going on, but maybe it's the case that remedies is an end run around this distinction, right? There are other ways, right? The extraterritorial treatment of method claims are very different than system claims. Offers to sell and sales under NTP are not going to be given the same reach that Transocean provided. If you don't know Transocean, that's where the Federal Circuit said it is the location of the sale that matters, not where the negotiations take place. So if I can do all of my negotiations to sell the invention in Hungary, and it ends up that the contemplated sale is in the United States, that's infringement, even if that sale is never completed, right? So it could very well be there's potential liability when there's no contact in the United States. Agree or disagree whether that's the right law, but that is the current law. That's not available to methods. Moreover, when you're dealing with trans-border uses of methods and systems, like in the NTP case, that case made it clear. Systems, you can have infringement. We determine the location of the use of the system, where the control is located, and where the beneficial use flows. So there, BlackBerry system, users in the United States are using it. Infringement is in the United States for the system, even though part of the system was in Canada. Method claims different, right? Because one step was performed outside the United States, no infringement of the method claims in NTP. Which again, you don't see that distinction in the statute anywhere. And you could harmonize this. If you look, there's a decision out there called Centillion where you're dealing with another divided infringement kind of idea. So it's not clear to me why we need to have these differences. Section 271F, dealing with exportation protections, are unavailable expressly and completely to method claims. That's the cardiac pacemakers case where the court in bank switched the rule where they had allowed it to apply to method claims. And in my view, you can't explain this distinction based off the presumption against extraterritorial application of U.S. law, in the main part because the Federal Circuit rarely talks about it when they're dealing with a lot of these extraterritorial applications. So another inconsistent treatment of method claims. Divided infringement scenarios are also different. It's tied to the extraterritorial aspect. For divided infringement of systems, you've got the Centillion rule, again, control and beneficial use. So if lots of parties own the components of the system, there's still an infringing use of the system if somebody controls it and receives the benefit. But that's not the case for methods, right? If somebody else is performing one of the steps, as we see in the Akamai line of cases, then there's no direct infringement unless there is sufficient control or reason to apply liability to that one actor. So that's an inconsistent treatment as well. And I think you could reconcile. You could treat them the same. There's no reason the Centillion rule and the NTP rule could not be used for method claims. Another one which I have to decide where I'm going to put this is the marking statute, right? The law is clear that if you're only dealing with method claims, the marking statute doesn't apply, which can actually be good because then there's no limitation on damages, right? You just go get everybody. But the statute does not specifically exclude methods, but it's interesting, right? It says patentees and persons making, offering for sale, or selling, or importing. So, right, use is specifically excluded, and so if you think that method claims can only be infringed by use, then effectively they are excluded. And of course, the marking statute contemplates some sort of article, right, that there has to be something that is actually marked. And so again, that's the law. I don't know that they've given it much thought other than to think, well, it's intangible, so there's nothing to stick it on. But I think there are other contexts where we do sort of marking type requirements, like in the service mark context, where we have other ways we require you to do something to show the use of the mark in the trademark context. Again, as an analogy, not a perfect fit, but I do think it's something worth rethinking whether we think that distinction makes a difference. Now, of course, the one area where I think it is appropriate to treat method claims differently than other forms of patent claims is in eligible subject matter, and yet we've gone the exact opposite way, right? Why do I think that makes sense? Because Section 101 actually says, here are the 4 categories of patentable subject matter. Maybe we should actually treat them differently, but in the post-Alice world, we have basically the lump and dump where we look at the method claims, do the 2-part test, and if the court concludes that we think those method claims are in eligible subject matter, by and large, any other claim, be they system or some other form, are also going down, which is exactly what happened in Alice, which to me was the biggest disappointment of Alice, is that I was hoping the Supreme Court would actually draw a line and say, here's something that is ineligible, here's something that is eligible, and unfortunately we didn't get that, and so we have very little guidance. And I think it's an interesting contrast to some of the earlier precursor cases to Alice, with even in Bilski itself, which was, if you look at it, specific to method claims, right? Bilski was not addressing the other areas. It was specific to how do you assess the eligibility of a patented method. And I can never pronounce it correctly. I call it Knighton, but I may be wrong. But that was the patentability of a signal that had a watermark on it. And there the court went through and did a categorical analysis. Does it fit into this category? Does it fit into this other category? I thought it was actually a great analysis, a great statutory analysis. That's gone. And so why do we care? To me, it's just interesting that we sort of have these bifurcations and different treatments without a lot of justification other than this fear that method claims are broad and intangible and ungovernable. I don't think that should be the case. Whether a method is broad is determined by the claim. Right? And so claims for certain methods can be incredibly narrow. Again, my pharmaceutical background coming in, where you've got very rigorous requirements. So I don't think that's enough to justify the differential treatment of the two. It's not clear. I don't think the court's done a great job of elaborating why they treat them differently. And I do think that there can be important consequences in terms of timing. When can you actually get into court if we just redefine what sort of acts of infringement there are? When can you actually get injunctive relief, right? So you can sue for infringement of a method claim where you've sold something that its only purpose is to perform the method, even if the method hasn't been actually performed yet, lets you get into court earlier. So I think there's some interesting timing dynamics that could play out. But at a minimum, I'm just sort of curious and confused at times by why the court takes a facially neutral statute and starts to add complexity in ways that doesn't seem to necessarily be adequately justified as a statutory interpretation measure. Thank you.
Okay. All right, so our last presenter is Professor Wasserman, and she's going to be presenting insights on the relationship between a patent examiner's application grant rate and the year in which the U.S. Patent Office hired that examiner. Professor Wasserman.
So I just want to start again by thanking the organizers of the conference, and in particular Keith and David, and congratulating you on this amazing center that you're launching. I'm really looking forward to following the events of the center in the future. So today, as you've been told, I'm going to be talking about an article that's really part of a larger project that explores determinants in the USPTO's decision making. And the article I'm presenting today is going to empirically examine whether the year a patent examiner is hired has any sort of lasting effect on what her granting proclivities are going to be throughout the tenure of her career at the PTO. This article is co-authored with Michael Frakes, who's at Northwestern. So what's the motivation behind this and my larger sort of research agenda? I think everyone in this sort of room has heard there's concerns that the PTO is issuing too many invalid patents, but I think there's also a general consensus that there's inconsistency in patentability determinations across examiners, meaning your decision on whether your application is going to be granted is not going to be driven only by the merits of your invention, but also by who you may happen to be randomly assigned to in the patent office. And of course, to the extent we would like the agency to be treating similar applicants similar ways, right, inconsistency across examiners is concerning. So now, despite the fact, right, as we've heard Chief Judge Michel tell us earlier this morning, that patent quality and consistency is really important to the health of the patent system, we don't have a lot of compelling empirical evidence that there are features that drive an examiner's decision to grant a patent outside of the merits of the invention. So as a result, we have policymakers who are attempting to increase patent quality without having good evidence about what are particular features that may be driving their problems that they see. So this article really builds on some of my previous work that tries to rectify this deficiency, that tries to provide some compelling evidence as to what are the determinants of the PTO's decision making. And as I note, this piece we're looking at whether the year you're hired by the PTO has a lasting impact on what your grant rate is going to be throughout your tenure. Okay, so for this crowd, very quickly, because I know everyone's probably up to speed on this, a background on patent examination, right? If you want a patent app, you have to file an application with the PTO. It's going to come in. They're going to look at the technology and assign it a patent class. They're going to use that to route it to an art unit, right, which is an administrative unit in the agency of anywhere between 12 to 20 examiners that review applications in the same technological field. Once it arrives, your application arrives at the art unit. It's then generally randomly assigned by the supervisor to an examiner in that art unit, and once it comes up on her queue, then she'll begin to review the application. Okay, so what's the theory behind cohort effects? That is, why do we think that the year you would be hired would have any sort of lasting effect on what your granting proclivities may be? So to begin, I think it's important just to note that examiners have a fair amount of discretion when they're determining whether, or when they're applying the patentability standards to an application, right? And there's a large literature that actually suggests that early moments of employment are important on how workers develop their practice style or learn to operate within their sort of bounds of discretion, right? So we begin by hypothesizing that patent examiners are particularly susceptible during their first year at the patent office, and that the initial conditions that they face at this time can have a persistent effect on what their granting behavior will be. So our first hypothesis is simply, right, that the year you're going to be hired is going to impact your grant rate that you follow throughout the course of your tenure. Now, given, right, this prediction that we're going to see a cohort effect that stems on the importance of these initial hiring conditions, one may predict that as those initial hiring conditions change, that your sort of cohort effect will also vary. So we think one of the important initial conditions that may have an effect on what your grant rate would be is what we call the agency's allowance culture. So this is just what we think is the emphasis that the agency is giving at one particular point in time towards allowing versus rejecting patents, right? Now, obviously, it's going to be hard to measure an allowance culture. Any culture of an agency is hard to quantify. So we're going to use as a proxy the quality assurance program at the patent office. And that can just be thought of as the layers of review an examiner's decision to allow a patent application will go through, or how likely, right, if an examiner allows an application, it's going to be subject to some second review. So you can imagine what we think is that with changes of sort of high-ranking officials, there may be sort of changes in the agency's allowance culture that sort of comes in, and they may use a quality assurance program to help change that allowance culture. So if you come in as a high-ranking official of the patent office and you think the agency is allowing too many low quality or too many invalid patents, you may choose to strengthen the agency's quality assurance program, sort of sending a signal to examiners, right, to apply more scrutiny to their decision-making. Conversely, if you come in and you think the agency has this culture of rejection, or that they're rejecting too many good patents, right, they may weaken the quality assurance program to counteract what they perceive as sort of a culture of, or overly restrictive granting culture. So utilizing this approach, we largely map out three different allowance regimes. We say in the 1990s, they had a more permissive granting culture. In the mid to late 2000s, a less permissive culture. And then from 2010 to 2012, where our data ends at 12, a more permissive culture. Now, I want to be really clear. We are not taking a normative stance, nor can we here. We're not saying one of these regimes is better than the other. All we're saying is that if you, for example, got hired in 2011, you may be hired in a regime, right, where there was a more emphasis on sort of allowing than perhaps in the mid to late 2000s. That's it. And also, even though we use a sort of quality assurance program to sort of map out these three regimes, we then do use other information. We conducted a lot of interviews with current examiners and past examiners and patent practitioners and high-ranking sort of officials at the agency, just to sort of make sure that they generally agreed that these were generally sort of shifts in the culture of the agency. And so that leads us to our second hypothesis, right, that patent examiners hired during a time period when the agency had a more permissive allowance cultures tend to have a higher grant rate throughout their entire career than examiners that are hired during a less permissive allowance culture. So finally, we also believe that the new hire training of examiners may also sort of have a lasting effect on what their granting proclivities are. That is, we think the longer, once you're hired as a new examiner, that you receive formal new hire training, the more likely are you going to be indoctrinated into the prevailing agency's culture at that particular time. And so what's nice for us is that during our time period of study, there was a pretty big change in how the Patent Office trained their new hires or their new patent examiners. Prior to 2006, you got about 2 to 3 weeks of formal centralized training before you were shipped off to your art unit. And you received then extensive training from your supervisor in your art unit, but it was more of an apprenticeship program. And then in 2006, they rolled out what they called an 8-month university-style training, where you could spend up to 8 months in sort of a centralized training before you were shipped off to your art unit, where you got additional informal training. And for us, in 2006, about half the examiners got the new 8-month training, and about half got the old training. So it's sort of this nice natural experiment for us. And they were, whether you got put into one or the other, was largely dependent upon the technology that you reviewed. And because we can control for technology, it's like it's almost you were randomly assigned to one versus the other. And so this led us to our third hypothesis, right, which is just the longer amount of time new patent examiners receive formal training, the more likely their grant rates are going to reflect the allowance culture at that time. I should also note, just to say, from 2007 onwards, you got the 8-month training. And I can discuss a little bit if people want to in Q&A. There was a slight change also in 2010 on the new hire training. Okay, so how do we go about testing this? What's our methodology? We utilize something called a rich fixed effects design. We just want to estimate the relationship between the grant rate and the year you were hired as a patent examiner. We've got to control for a whole bunch of other stuff that could affect what your grant rate is, right? What technology you're in, the year the application was disposed, your GS level as an examiner, which affects the amount of time you're given to review an application, tenure effects, whether you stayed at the PTO for a short time or a long time, as many things as we can control for. Now, to do this, we need really rich data, because we're going to be able to have to decouple sort of a cohort effect, the year you were hired effect, from all these other things. So we needed to collect data, and we did this. We collected information for all 1.4 million utility patent applications from PAIR, which is the public database from the PTO. So for each one of these, we collected information on the examiner that was associated with it, whether or not it granted or not, the technology that the patent was directed to, amongst some other information. We also FOIA'd the PTO to get a lot of information about examiner characteristics. Matched all these based on examiner names, and our database has about 9,000 unique examiners in it. Okay, so let's get to the good stuff, which is the results, right? Do we essentially see a cohort effect, meaning does the year you get hired affect what your granting proclivities, and do they follow our predicted patterns? Okay, so what I'm showing you here, let's see if this works, is I'm showing you a relationship between what your grant rate is going to be versus the year you were hired, and we're zeroing this out to the reference year of the 1993 cohort. Okay, so to be clear, you're going to interpret what I'm showing you here as trends in the inherent grant rate across different cohorts of examiners based on the year they were hired. So this point here is not what was the mean grant rate of the PTO in 1999. What it shows you is what's the mean grant rate of examiners that were hired in 1999 throughout the course of their career, controlling for all those things we showed you in the other slide, right? So this is trying to isolate just the effect of the year you were hired. Now, if we didn't think we have a cohort effect, this should be flat. But what we see is that it matters, right, essentially what year you get hired. And just to be clear, this is also not driven by the fact, like in 2003, if the PTO just starts hiring examiners in like a technology that has lower grant rates, that's not what's driving our results, because we're controlling for technology. The other thing to point is it's fairly substantial, right? If you were hired in like 2007, your mean grant rate is about 11 percentage points lower, or 16% lower than the mean grant rate of the 1993 cohort. And then I also want to note that it generally also follows our trends that we thought, right? In 1990, there's a more permissive culture, so you tend to have a higher grant rate throughout the course of your career when you were hired then. The mid to late 2000s, if you were hired during that period, you start off on a lower sort of granting pathway, and then at the end, 2010 to 2012, we see an uptick. Now, I want to emphasize what we think is, if you get hired in 2005, let's say you get hired in a regime under a more restrictive culture, we think you start off on a lower pathway and you stay there, even in comparison to a cohort in the 90s, right, if you looked at that same year. So let me show you that clear on this slide. Okay, so what I'm showing you here is that I'm taking a 1993 cohort, which is from a more permissive regime, and I'm showing you what their grant rate is. That's what this blue line is, and how it evolves on a year-to-year sort of basis, right? And as they essentially get to the mid to late 2000s, you notice their grant rate starts to go down a little bit. So this is when the agency arguably took a more restrictive granting culture. But it doesn't dip as much as we may have thought if they hadn't started this higher granting pathway. So I'm comparing this to cohorts hired in 2005, 2006, and 2007. These were hired during a more restrictive regime. Notice they start and stay below, right, the 1993 cohort for all the different years. Okay, and then finally I want to show you our results on training. Okay, so remember 2006 was where we had this nice natural experiment, and we thought the longer you had new formal training, the more likely you would be indoctrinated to the culture of the agency at that time, which was a more restrictive culture. So we thought if you had the 8 months training, which is what's shown over here on the right, you're going to end up with the lower grant rate than if you just had the two-week training, right? So this is the same figure I showed you for figure 1, right? This is the cohort effect with controlling for everything on a year-to-year basis. Okay, so we think there's lots of implications. So to the extent, for patent policy and for those who sort of study the administrative state more generally, so one of the concerns, right, is if you're concerned with inconsistency on patentability decisions, it's important to sort of take into account the cohort effects, right? If you're going to try to do some sort of policy intervention to bring more consistency across examiners, then you need to start thinking about the year the examiners get hired and doing that. And I'm just going to stop so we can get some questions, but thank you.
Thank you. Okay, so I think we have, thank you, Professor Wasserman. So I think we have time for a few questions. So I would actually like to open it up to the audience first. If anyone has any questions for our panelists, please raise your hand. Yeah, go ahead.
Former patent examiner hired in 2005. Why is it interesting because I allow very few patents. But one thing I always thought was junior examiners allowed a lot less patents
Yes.
than when they became primaries.
Yes.
And when you were looking at your data,
Yes.
you see a trend once they
Yes.
hit the 13, 14 level where they start allowing more because
Yeah.
it wasn't that set level.
Yeah, so that's a great question. So we have another paper that looks at essentially the GS level of an examiner, and we control for everything sort of over time. So we take individual examiners and we look at what happens to their grant rate as they get promoted throughout their tenure at the PTO. And we find the grant rate steadily increases as you get promoted each time. And we thought that was in part because what your GS level is, right, affects the time or your quota, right? And as you get promoted, you essentially get less and less time to review each application because you're expected to review more. And so we found both that as you get promoted, you cite less prior art, you make less time-intensive obviousness rejections, and your sort of grant rate goes up. But we're not able to really decouple that in part from the change in the scrutiny effect from once you become a supervisor or a primary examiner.
Yes, on your data, when you look at allowances and rejections, are you looking at only original applications, or are you looking at RCEs
Yeah.
and divisionals
Yes.
and other things?
We're looking at everything, and we are controlling, so RCs right, is one application throughout the entire time, where continuations, right, you get a new application number. And so we have everything in there, and then we do control for continuations, because there'd be concern, right, that your grant rate might be a little bit higher for a continuation than an original application.
So I had a question for you, Peter. You mentioned that one of the solutions was that was proposed was just broadly strengthening copyright enforcement. And I was wondering if you might give us a few more details about what in that proposal, what were the specifics in that proposal, and if you had an opinion on whether or not those proposed measures would actually work.
So some of the proposals that have been going on, one is about felony streaming. And so, and they are trying to raise the criminal penalties that focus on streaming, so that it's not just a misdemeanor, but actually move it up to a level of felony. I think that's one example. The other one, which is very controversial, is what we call internet border control. It's basically you're blocking the entry of information from other places. So if you happen to have movies coming from Pirate Bay or from Hungary or from China, then you basically block it right here. The biggest concern I have is that the more you block it, the more it is difficult for us to actually argue that other countries should stop having a repressive regime on the internet. Because if we start blocking information, it's actually not that easy for us to say, well, we are blocking only for copyright infringement purposes, but you are not allowed to block for national security purposes, right? It's actually a very hard argument to make, even though we tend to believe that there should be a separate divide between what is considered as economic and what is considered political. Another example, which I think is going on in Australia and a lot of places, is to stop allowing geolocational tools that will allow people to use proxy server. And that, again, is also somewhat controversial, because proxy servers are also some of the tools that people have been used to circumvent censorship in a lot of regimes. China is a very good example. If you want to work in China, you better have a VPN. It's not only just for communication through your Gmail and other things, but also about protection of your trade secret. Right, so there are a lot of major issues there. But once you block once you prohibit the use of proxy server, imagine how hard it would be for a lot of companies trying to do business in China. And so I think if we can draw the line easily just based on creative content, that would be easy. Unfortunately, when you actually look at the larger issue of, for example, communications policy, I don't think it's that easy to draw the line. And when you throw in 180 countries, it becomes even more complicated.
Thank you. All right, and I have one question for you, Professor Holbrook, and that, so I know you're still formulating your ideas about what to do about this problem, but do you think a statutory fix is necessary, or would it simply be that the courts need to be aware that they are treating method claims differently, and that awareness in and of itself might solve the problems that you highlighted for us?
Well, I think in some ways they're aware of it. What I think is the courts, in my view, should actually revisit whether that distinction is legitimate or not. I think they sort of default into it at times. The weird one for me is the BlackBerry case, where they, out of the sua sponte, sort of create this bifurcated world between systems and methods that, to me, seems utterly unjustified by the statute. So I don't think I'm calling for a statutory reform, although Congress could do that, of course. But what I would like to see is a more rigorous explanation for why this treatment is justified. And unsurprisingly, I don't think it is. I think there's lots of ways that you can treat them and should treat them similarly for a host of economic innovation-based reasons. So for me, it would be the courts revisiting that. Revisiting those particular doctrines. And particularly, I thought Akamai was a lost opportunity. That in some ways, I'm happy with what happened this summer and the way they rethought the divided infringement scenario, but I thought the other way they could harmonize is say we will treat method claims the same as process claims and we'll use the centillion test for both. But they didn't take that step.
Any other questions for our panel? Yeah.
So it's kind of related to the last question, but in the drafting and prosecution side, typically these method claims compensate for this different treatment and litigation?
I mean, I think a prudent prosecutor would recognize those differences and try and draft accordingly, right? So that if this particular area, and you've got to be careful in technological field, in the pharmaceutical area, method claims, again, are the second best choice, although they're helpful if you're trying to evergreen or something like that. But I do think, I guess as a pejorative term, I don't think of it that way. Sorry. So I think a prudent prosecutor has to be aware of that, which adds to the complication, right? That prosecutors may not be as immersed in the infringement doctrines as you may expect them to be, and drafting claims in certain ways are now going to have considerable consequences in litigation based off of these non-textual interpretations of the infringement provisions. And so I think that's problematic. There could create some risk. So yes, they should be aware of it, but prosecutors then have to be really, really paying in-depth attention to what's happening on the litigation side, because you don't have anything else to do, right? So, yeah.
All right, please join me in thanking our panelists.